So we will, and this is also being recorded, obviously, so this will be sent out to anybody who RSVP'd. So we hope that you stay on for the duration, that Mr. Simmons will be giving this wonderful presentation with so much great information. But if for some reason, we know that you guys are busy running your businesses, so if for some reason you can't stay on, this will be emailed to you, hopefully in the next probably day or two. So it is 1 o'clock. We want to be really cognizant of your time. Sorry, my email notifications are going off. But let's go ahead and get started. So my name is Katie Galan. I am the Director of Education and Community Engagement for Better Business Bureau, serving the heart of Texas. I am here in Corpus Christi, so I take care of the coastal Bend area, but we have, regional offices all over most of Texas. We cover 105 counties here in the state. So even if you are logging in from some of our other regions, I'm still happy to help you. I help out in all of the other regions that we have. So if you guys have any questions for me or for Mr. Simmons as we get going through this presentation, please feel free to put that information into the chat and we will get to them at the end of the presentation. So I do want to go ahead and introduce Mr. Simmons here and give you just, I know you guys know what you logged on for, but just want to give you a little synopsis of what we're going to go over today. So we are going to go over the changes in salary requirements for salary exempt employees, significant employment law developments for employers, including non-compete agreements, workplace policies, and TWC rules for legally paying employees. So a lot of really great information. I do want to give also a quick background on Mr. Simmons so that you guys are aware, and his bio was on the event, but just to give you guys some background on Mr. Simmons. So Mr. Simmons serves as legal counsel for Commissioner Joe Esparza, the employer representative on the Texas Workforce Commission, and he advises the commissioner on agency rulemaking, final level unemployment, wage claim, and tax appeals. He assists business groups with employment-related legislation and counsels employers on Texas and federal employment laws. Mr. Simmons has also served as legal advisor to the commissioner representing employers since 1987, and has given over 2,600 talks before employer groups. So he has also authored the TWC book, Texas Guidebook for Employers, and was the assistant editor of the Employment Law Handbook of the Texas Association of Business during its time of publication. So some recent awards for Mr. Simmons from employer groups include the Texas Payroll Conference, the Texas Association of Business, and in 2018, the National Foundation for Unemployment Compensation and Workers' Compensation, UWC, recognized Mr. Simmons with its J. Eldridge Hill Jr. Award for service to the employer community in the public policy arena. So we're really excited to have Mr. Simmons here today and all of his expertise. Please take advantage of the fact that we have him here today and ask any questions that you have. I want to make sure that you're getting everything that you can out of this session. And also keep a lookout for more of our webinars that we have coming up. We're trying to do this every single month. We likely won't have anything for December, but please keep a lookout for the remainder of the year beside December, because these are free to you, and we want to make sure that we are providing you necessary education that really is going to help you and help your business. So be on the lookout for that information. So with that, I'm going to hand it over to Mr. Simmons.
Thank you very much. And I'm really pleased and honored to be invited to speak with y'all today about these employment law updates, in particular the wage and hour law regulations that were recently changed by the U.S. Department of Labor. We're going to be focusing on those and also taking a close look at some other employment law update topics. And so hopefully everybody can see the screen right now.
Yes, we see it.
My first slide, and you see my email address is there, third line from the bottom, and I invite everybody to send me questions via email, and the online version of the book that I write for the agency, the Texas Guidebook for Employers, is the second line from the bottom. That's got its own web domain, so it's real easy to find, efte.twc.texas.gov. And the toll-free number for employers is at the bottom left, 800-832-9394. And my personal direct number in my office is at the bottom right, 512-463-2967. And I just again like to invite everybody to feel free to contact me via email or by phone and let me know what kind of questions you have. Now, let me see if I can, first, before we get into the tall weeds of some of the more complicated regulatory changes, I wanted to share a few basic facts about the wage and hour laws so that we are all on the same page. The nation's main wage payment law is the Fair Labor Standards Act, and that's where the requirement about paying a certain minimum salary to salaried exempt employees is found in the regulations under that law. The Fair Labor Standards Act covers minimum wage, which is still $7.25 per hour. It also covers overtime pay, which is time and a half based on the regular rate of pay for all hours actually worked over 40 in a 7-day work week. And then it also regulates child labor. And finally, it regulates equal pay, which means equal pay for men and women who are doing the same job at the same level of skill and qualification and responsibility. Men and women who are doing the same job under the same circumstances really should be getting the same pay. And if they don't, that's potentially a gender discrimination issue, which is why the EEOC enforces that part of the Fair Labor Standards Act. Now, on a state level, the main wage payment law, which is also enforced by my agency, the Texas Workforce Commission, is called the Texas Payday Law. And that's in Chapter 61 of the Texas Labor Code. And basically, the focus of that law is on enforcement of the wage agreement, whatever the wage agreement is. And the basic rule of paying employees legally and properly. And you'll find this kind of a law in every country in the world and in every society that has ever existed in recorded history. You'll find a version of the fundamental rule, which is pay an employee in full according to the wage agreement that was in effect when they did the work. So basically, keep your promise. If you promise to pay a certain amount to an employee for doing a certain job, then that's an enforceable promise. So that's the main focus of the Texas Payday Law. It also requires timely payment of wages on regularly scheduled paydays that are published by the employer. And there's actually a required poster for publishing the paydays. Non-exempt employees, that means people who are not salaried exempt and they're eligible for overtime pay, they have to be paid at least twice each month. So daily, weekly, biweekly, or semi-monthly. Salaried exempt employees can be paid once per month, but most employers go ahead and pay all of their employees twice each month. Wage deductions are tightly controlled under the Texas Payday Law. Under that law, there are 3 categories of legal deductions from pay. Deductions that are ordered by a court, like child support, deductions that are required by law, like payroll taxes, and then the third category is deductions made for a lawful purpose and authorized by the employee in writing. So basically, if a deduction has not been ordered by a court and it's not required by a law, then it needs to be made for a lawful purpose and authorized by the employee in writing, which is why we recommend that all employers have all of their employees sign a clear written wage deduction authorization agreement. I'll come to that again later in my talk, but just to let you know, in the book that I write for the agency, that's got a whole section on sample forms and sample policies. One of the sample forms in there is an example of a wage deduction authorization agreement, showing the types of deductions that are commonly made by companies and how companies normally do that. And it's the kind of thing that TWC looks for in a wage claim case. And the Texas Payday Law also regulates final pay, which is, the deadline that is on the final wages for an employee who leaves the company. And just real quick, the final pay deadline depends upon the nature of the work separation. Basically, if an employee quits, that means they leave voluntarily, they initiate the work separation, the deadline for paying them is the next regular payday following the effective date of resignation. So just pay them out on the normal pay cycle. If they leave involuntarily, that means they're laid off or discharged, they need to be paid within 6 calendar days of the effective date of layoff or termination. And I'll have more detail on that in just a minute, but that is the main focus of the final pay requirements. Now, these laws are pretty interesting for what they don't require. Neither law requires breaks. Under Texas and federal law, breaks are not required. Basically, the only break, I suppose, that would be required is health and sanitation. I'm sure you can guess what agency has that. It's OSHA. The OSHA requirement to give employees reasonable opportunity during the day to have restroom breaks. But aside from that, breaks are governed by policy, like coffee breaks, rest breaks, waste your time on Facebook breaks, any smoking breaks, lunch breaks. Those are all governed by policy, and employers should be clear about whatever breaks are allowed during the day. Premium pay, paying more than time and a half, is not required. Shift differentials, paying people on one shift more than people on another shift, that's not required. Raises are not required. Fringe benefits such as paid leave, paid holidays, and severance pay are not required. But under the Texas Payday Law, if paid leave or paid holidays or severance pay has been promised in a written policy or other form of agreement, then it's an enforceable part of the wage agreement under the Texas Payday Law. Pension benefits, retirement benefits are not required. Expense reimbursements are also not required. Now, it is true, though, because of, for the purpose of being competitive in a sometimes tight labor market, almost every company will reimburse 100% of properly documented business-related expenses. But it's absolutely required only if not reimbursing business-related expenses would have the effect of taking the employee's pay below minimum wage for the work week involved. So the details really matter. And sometimes in close cases, that's when you might want to give us a call at the toll-free number or send an email and just run a situation by us. And don't worry, we don't talk and tell in our office. Our office is safe to contact with questions. You might worry about, well, you're with a government agency, you're a government lawyer, that makes you double trouble. I'd be scared to, ask a question because then I'll get audited or something like that. That's not true. We do not send out audit orders or anything like that on anybody who calls with a question. And you don't even have to identify yourself if you don't want to. You can call in and say, I'm just calling to find out something and not even give your name, or you can say, I'm calling for a friend or something like that. So don't worry, if you have a question, we would like to hear about it. It's like your teachers probably told you when you were much younger, the only dumb question is a question that you don't ask. So don't be shy. All right. I earlier mentioned how important minimum wage is. Up on the screen is a complete list of all categories of legal deductions below minimum wage under the federal law. So all of these categories of deductions are legal under the federal law if they take somebody's pay below minimum wage. The thing to remember, though, is the Texas Payday Law is always in effect. So it applies to any private company, any private employee, no matter how small the company is, even charitable nonprofits, even churches. These are the categories for minimum wage. But remember, under the Texas Payday Law, a deduction is legal if it is ordered by a court or required by law, or if it's made for a lawful purpose and authorized by the employee in writing. And up on the screen, the top two categories are the only ones that you don't have to get written authorization for. Every other one of these deductions would have to be authorized by the employee in writing. So that's why it's really important to have all employees sign as part of their employment, a document in which you cover the issue of what deductions might be taken from an employee's pay. And I would suggest that it might be a good idea, if you don't have a form like that, take a look in the book, the Texas Guidebook for Employers, look for the sample wage deduction authorization agreement, and use that as a starting point. And of course, every company is different. Every company, makes its own kind of deductions, but that will give you a good idea of what the most common ones are. Because overtime pay is really important. It's really important to know what goes toward overtime, what counts toward overtime. And basically, overtime is owed only on hours actually worked in excess of 40 in a 7-day work week. Overtime pay does not include hours not actually worked, but that might be payroll hours under a fringe benefit policy, like paid leave or holiday pay. If somebody gets a combination of paid holiday or paid leave time plus work time during the week, and it happens to be over 40, the paid leave hours or paid holiday hours don't result in overtime because those are not actually worked. So take a look in our book in the article in part 2 of the book about calculating overtime pay, and you'll see a discussion about this. And give us a call if you have any questions. But basically, you want to count as hours worked anytime that the employee is at your company's disposal in such a way that they can't use that time effectively for their own purposes. Like if they're on call, you don't have to pay for all of the on-call time, just the time that they are on duty responding to calls. You don't have to pay them for the time that they are off duty while they're on call, such as the time they spend sleeping or eating or watching Netflix at home or mowing their lawn. That's not work time. It doesn't count toward overtime. Just the hours actually worked. Waiting time, that's when they're following instructions and they're at the place where you told them to be when you told them to be there, and they're waiting to be told what to do. All of that waiting time counts as work time. Breaks count as work time if they're just ordinary rest breaks. But meal breaks do not count as work time as long as they are fully relieved of duty and they're able to eat a meal in peace. And they're not being, distracted or bothered by, other people. So if it's going to be a true meal break, it's not going to count as time worked. Make sure that, nobody bothers them during that time. And if that satisfies the criteria, then you can treat that time as being off the clock. Sleeping time, that's for like home health care. If you spend overnight with a patient, that counts as work time if the employee is not able to get at least 5 hours of uninterrupted sleep. Preparatory and concluding activities, that's the time spent before and after each workday, after the main duties of the job, the time spent preparing to do the main duties, and the time spent cleaning up and putting away. Usually that counts as work time if it's an integral part of the main activity, the main duty. So in most cases, that's going to count as work time. Time spent in job-related meetings like mandatory staff meetings or something like that, that counts as work time. Time spent in company training, even if it's on a day that the employee is not normally scheduled to work, that counts as work time because it's job related and they need to be there. If they're not there, they're going to get in trouble. That's what makes it work time. Travel time, the normal commuting time, getting to work and getting back home at the end of the workday, that's not work time. But what is work time is travel between job sites during the workday, travel that's all in a day's work, all of that counts as work time. And if you send somebody to a another city, let's say they normally work in one city, but you send them on a special one-day assignment in another city, the extra travel time over and above their normal commute is going to count as work time. And if you send them out of town and there's an overnight stay involved, then all of the time they spend traveling within their normal range of hours worked counts as work time. But the time that falls outside their normal range of hours worked does not count as work time if they are simply a passenger and they're not expected to do any work while being a passenger. So, once again, remember, time worked does not include paid leave. That's just paid at straight time. Concerning working off the clock, there's no such thing as legally working off the clock. If you're a non-exempt employee, you got to be on the clock while you're working, and all hours have to be accurately recorded by the employer and properly paid for. So never let employees work off the clock. There's no such thing as voluntary overtime. Also, if somebody's working extra time without authorization, like they're not taking their lunch break, but they're working through their lunch break, if you know or should know that they're working during a particular time, then it's your obligation as an employer to pay them for that time. Now, if you don't want them to work that kind of time anymore in the future, then it's up to you, the employer, to use your authority as an employer to prevent the work from being done, which, if it has to happen through a corrective action procedure or disciplinary action process, so be it. But it's a matter of, basically letting the employee understand that the company means business when it says take a lunch break, so that, you don't have to pay for that time. Now, getting to one of the big topics under wage and hour law right now, I'm sure everybody has heard that the U.S. Department of Labor recently increased the minimum wage for a salaried exempt employee. And that's true, they did. Effective July 1st, the minimum salary, the salary threshold for a so-called white collar exempt employee, one of the executive, administrative, professional type exemptions, called EAP for short, is now $844 per week. It was $684, but for a couple of months now, actually almost 3 months, it's been at $844 per week. Below that, the employee is presumed to be non-exempt and eligible for overtime pay. So be real careful about that. The minimum salary is going to go up to $1,128 per week, effective January 1st, 2025. So watch out for that date coming. For white collar exempt employees, salaried exempt employees, there's both a salary test, which is, the $844 per week amount, and there's also a duties test. Their duties have to be exempt in nature. Their primary duty has to be exempt in nature. So basically, these are the top leaders of the company. With salaried exempt employees, the focus is not really on the hours they work, because you can't standardize their work with respect to time. The focus is on the results that they are achieving. Are they getting the results, for their job that the company needs? And so you can see that if you look at a classic example of an exempt salaried employee, an executive exempt employee like the president of a company or a CEO. Basically, they're at the top of the company. They have hiring and firing authority. You can't standardize their work with respect to time. How many hours does it take to be the president of your company? Nobody knows. And anybody who has been in that position knows very well the unpredictability of such hours. That's why it makes sense to pay them a salary. Another thing about exempt salaried employees, generally they're at the highest levels of the company in terms of seniority or rank and responsibility. And so other employees look to them for leadership within the organization, and their jobs affect the company as a whole. And some examples are, like I say, president, but also vice president or general manager, a chief financial officer, anybody who is in charge of an entire department of an employer, like payroll or HR, somebody who is a licensed professional, like an engineer or an architect, or a software programmer or a network designer. Those are good examples of white-collar exempt employees. Now, y'all may have heard that there have been some court lawsuits filed in Texas courts and also other courts around the nation concerning the new Department of Labor salary rule. And in Texas, there are at least 3 that I've found. And the only one that has had a decision is this one listed on the bottom bullet item here: State of Texas versus U.S. Department of Labor, and that's up in the Eastern District Court of Texas, Sherman Division. On June 28th, just a few months ago, the judge basically ruled that the Department of Labor's rule was unconstitutional and unenforceable as to the state of Texas. This ruling only covers the state of Texas and its agencies. So, my agency, of course, is covered by this. I'm personally not covered because I'm an attorney, and attorneys are exempt from all of the requirements. We can be required to work, unlimited hours for no additional pay, and we don't even have to be paid anything on any basis. Along with doctors and teachers, we're exempt from everything. But this Department of Labor regulation was declared unenforceable for the state of Texas by this State of Texas versus U.S. Department of Labor case. There are 2 other cases that are going on right now. One of them in the same court. The Plano Chamber of Commerce has sued acting Labor Secretary Sue, and the case is still pending. Private business groups brought that regulation. Also, there's one other in the Northern District of Texas, Flint Avenue LLC versus Department of Labor. No decisions yet, so we don't know how those are going to go. Now, real interesting thing, on September 11th, just a couple of weeks ago, there was a decision by the 5th Circuit Court of Appeals in New Orleans, which is over the federal district courts in Texas. And they ruled that the Department of Labor does have the statutory authority to establish and update a salary test for the EAP overtime exemptions, the white-collar overtime exemptions. But this case was based on a 2019 Department of Labor rule under the Trump administration, and not on the 2024 rule under the Biden administration. So the interesting thing about that is the Mayfield case, Mayfield versus U.S. Department of Labor. Mayfield was a private, business, and they lost their case. Basically, they were saying that the Department of Labor doesn't have any authority under the Fair Labor Standards Act to establish a salary threshold for the EAP exemptions. And the court said, no, that's wrong. They've got that authority. They've exercised that authority since 1938 when the law came into existence. So that's not the problem. The problem was, as pointed out by the district court in Sherman, was that the most recent Department of Labor regulation that went into effect July 1st, that impermissibly emphasized the salary test over the duties test. So as the court pointed out, both tests are really co-equal and co-important. One is not more important than the other. And so that's why the most recent rule was tossed out by the district court in Sherman. We don't know how the Fifth Circuit Court of Appeals is going to treat that. I'm sure the Department of Labor is going to file an appeal, but we haven't gotten word on that yet. Now, returning to the Texas Payday Law, basically it covers every private sector employer and employee in Texas, even the smallest mom and pop stores, even charitable nonprofit organizations, and even churches. So it covers everybody. And to minimize the risk of a payday law wage claim, make sure that all employees sign clear written wage agreements. That's something that's not a requirement. It's just a best practice. It's a good, strong recommendation. You want to make sure that everybody at every level of the company has signed a wage agreement. Even the top people, even the president of the company should sign a clear written wage agreement. And usually they're going to have employment contracts, and it's going to be in the employment contract. But everybody should sign a wage agreement because that gives the company the best evidence of the wage agreement. Whatever the wage agreement says, that's what should be done. So just make sure that the company upholds the wage agreement that it has made with an employee. Be careful about commission and bonus agreements. Those receive special treatment under the payday law because, like, the normal final pay deadlines don't apply to commissions or bonuses. If a different timeline for paying a commission or bonus is specified in the commission or bonus agreement, then that different timeline will apply, not the 6-day rule or the next regular payday rule, but rather the timeline in the commission or bonus agreement. But the tricky thing about commission or bonus agreements is that very often companies get into trouble by not making them specific enough. You want to make sure that they are as specific as possible, showing all of the conditions that are required to earn a commission or bonus and to receive a commission or bonus. And if there are any disqualifiers for commissions or bonuses, those should be in the agreement. If there are any deductions or chargebacks against commissions or bonuses, those should be specified in there so that the employer can argue that it followed the agreement as it was structured. So just be real careful about the details. And again, if you have any questions on things like that, I'd welcome hearing about it, and I'll give you the best information that I can. Make sure that the company gets written authorization from the employee to make any wage deduction that is not ordered by a court or required by a law. Dangerous things to do, things that usually result in trouble for a company: holding paychecks, pending return of company property. That's just not allowed. A company's duty to pay wages on time is separate from an employee's duty to bring company property back. Both duties exist and both duties should be fulfilled, but they're separate. So even if an employee hasn't returned company property, the employer still has to pay. Now, there can be conditions on that, and I'll talk more about that in just a little bit, but you want to be very, very, very careful about ever holding a paycheck and holding paychecks because they haven't submitted a written resignation or they haven't done an exit interview. That's not going to work. So try to avoid things like that. And in any situation involving the Fair Labor Standards Act, such as minimum wage, overtime pay, or a salary for a salaried exempt employee, TWC will apply the Department of Labor regulations for the Fair Labor Standards Act. So be familiar with those. And the book has a lot of articles about both federal and Texas payday laws, wage laws. Now, shifting gears just a little bit, getting into the area of what kind of policies are important for an employer to have, and recent legal developments in the area of policies. There's a few things to keep in mind for any employee handbook, any kind of policy handbook for employees. Basically, any significant policy or requirement should be in the handbook so that everybody can be on the same page, so to speak. about what is expected of the employees and the company. Try to address all of the important aspects of the employment relationship. One important aspect is the expectations that an employer has. Employees should have good attendance. They should, ask for leave in advance in certain ways. What are the job requirements? What kind of conduct is expected at the workplace? And a drug or alcohol policy. Expectations of employees. Expectation to be paid properly and on time. Company benefits. What procedures are in place for filing grievances or complaints? Will I be, given equal employment opportunity, especially if I'm a minority employee? Sexual harassment, do I need to worry about harassment? And what kind of privacy rights do I have? And then finally, administrative issues, such as changes to the handbook, how changes will be made, and what kind of representations and disclaimers apply in a handbook. Usually the most common disclaimer is all employment within the company is on an at-will basis, and may be terminated at any time for any reason by the employer or the employee. And in the book, in the Texas Guidebook for Employers, there are 2 or 3 different disclaimers in that regard. So take a look at the book. Golden rules for policies. These will really go a long way toward preventing unnecessary claims and lawsuits. Treat employees according to rules and standards that are well known. Treat everybody consistently. Don't make exceptions unless there's an absolutely compelling reason. It's a good general rule to never let employees be surprised by an action, except you can surprise them with a pay raise. They're probably not going to file any complaint about that, but anything else that's not welcome, they don't want to be surprised by it, because that often leads to claims and lawsuits. So there are some things that should never be provided for in a company policy handbook. One of them is what I mentioned earlier, holding of paychecks. Don't have any policies about holding of paychecks. You don't even need to put it in there that don't worry, we're going to pay you on time. You don't need to put something like that in there because that's already a requirement. Don't waste space in a handbook on obvious legal requirements. But also don't have anything in there about we're going to hold your paycheck unless you do an exit interview or return all company property. Just don't have that in there. It's too much trouble. Don't provide for minimum wage and overtime pay violations. Like, we're going to, sometimes people will need to work off the clock, or if you don't properly record your work time, those hours will not be paid, or they'll be paid at a reduced rate. Those are real risky, so more on that in just a minute. Don't have any policies preventing employees from talking about their pay and benefits with each other. Salary discussion policies, those are illegal under the federal law known as the National Labor Relations Act. They also have a right to talk about their working conditions, like whether they like a supervisor or not, whether they like their work hours, and things like that. They've got the right to talk between themselves about things like that, and don't try to interfere with that, because that just leads to trouble from the National Labor Relations Board. Another potentially troublesome thing is non-competition agreements. Those are extremely tricky. More on that in just a minute. Don't have a policy against the filing of unemployment claims because that's just flat out unenforceable and it's against the law. It's actually a criminal law violation. And finally, don't provide for a reduction in the rate of pay for the final pay period. That is possible. It is legal, but the only way we would ever recommend it is if it's part of the written wage agreement signed by the employee. I'll talk about that in a little bit more detail in just a minute as well. So first, remember, no holding of paychecks, pay them on time, and find other ways to get the property back, such as property return security deposit. That's something that some companies use. And there's a sample policy and a sample deduction agreement for a security deposit in our book. So take a look in our book. You can put conditions on bonuses and commissions, but those aren't really
I don't know.
those aren't really well placed in a policy handbook.
Right.
Those are best kept exclusively for the wage agreement itself. As far as minimum wage or overtime violations, any policy or agreement to be paid less than minimum wage or not be paid for overtime is null and void, totally unenforceable. So I already talked about the few categories of legal deductions below minimum wage. Those are very, very narrowly tailored. So be careful about that. Under the National Labor Relations Act, companies have to allow employees to discuss their pay and benefits and working conditions with each other. Now, one of the things that they don't have a right to do, they can talk about their own pay and benefits, but if they're talking about the pay and benefits of other people, and the only reason they know that is because they snuck into somebody's drawer when they weren't supposed to be there, and they took confidential company payroll information out, and that's how they discovered somebody else's pay. So they're talking about somebody else's pay. That's not protected under the law. So it really matters. The details really matter on something like this. Concerning non-competition agreements, y'all may have heard that the Federal Trade Commission actually attempted to ban almost 99.9% of non-competition agreements nationwide from top to bottom. Even if they were long-standing agreements, even they were already in existence, the FTC rule declared them unenforceable and basically in violation of fair competition and so on and so forth. That's a good example of sometimes how federal agencies grab too much at once, and a court basically invalidated that rule in Texas. The Northern District of Texas ruled on August 20th, 2024, so just about a month and a half ago, that the FTC ban on non-competition agreements is unlawful and cannot be enforced, and that has nationwide effect. So that rule is basically on hold. They might file an appeal. We haven't heard that they filed an appeal yet, but they do have the authority to conduct case-by-case enforcement, but it would be under the aspect of does a particular non-competition agreement limit fair competition in a particular case? And that's a much bigger burden, and usually a big government agency is not going to just do one case at a time because the economies of scale don't justify it. But be very careful about non-competition agreements, because under Texas state law, under section 15.50 of the Texas Business Code, they're already very, very tricky. And my recommendation is don't even attempt a non-competition agreement by yourself. This is something that you really and truly need a business law attorney to do for you, because the requirements are so complex, and there's a lot of different court decisions that restrict the non-competition agreements, and it's very, very tricky. So don't roll your own. Always get professional legal help on something like that. Also, FTC wasn't the only agency on the federal side that doesn't like non-competition agreements. The National Labor Relations Board also doesn't like them, because their position is that it has a chilling effect on employees' ability to look for and talk about better jobs. So an alternative that you can have, if you are legitimately worried about company secrets getting out because of like unfair competitions, your employees get trained by your company and then they go to your competitors, consider an alternative such as a trade secret protection agreement or a non-disclosure agreement. those are much more enforceable, and they're easy to get drawn up by an attorney as well. Also, it is okay to have in your policy handbook a prohibition against competing against the company while you're employed. Like, thou may not compete against thy company while you're employed with us. I mean, you can have a flat out requirement like that, and it is fully enforceable because basically that's a conflict of interest. And in the book, if you take a look in the Texas Guidebook for Employers, there is a sample conflict of interest policy in there that you can take a look at. Also, never attempt to limit somebody's right to file an unemployment claim under the Texas Labor Code. That's void and unenforceable, and it's a criminal violation. So just don't do it. All right. Finally, a lower pay rate for the final pay period. That is allowed. It is allowed to pay somebody a lower rate of pay for the final pay period, but there's only one way that I would ever recommend it being done. And this is the only way I've ever seen it work. And I've seen this work multiple times because I'm the attorney in Commissioner Esparza's office who works on all of the final levels of wage claim appeals that come before the commission. And in the wage claim cases that involve, like alleged unfair reduction of the pay rate for the final pay period, the TWC always accepts it if it's part of the wage agreement itself. So you want to be careful. And in the book, there's a sample paragraph showing how you can work that into a pay agreement. Basically, I understand and agree that my pay rate for the final period of pay will be fill in the blank X amount lower than it usually is, unless I satisfy the following conditions. Number one, I give at least 1 week's advance written notice of resignation if I resign. Number two, I return all company property in good shape minus normal wear and tear to my supervisor. Number three, I give my passwords to all my company files and folders on the computer network to my supervisor. And condition four, whatever the company wants. But, if they satisfy those conditions, then they don't get the pay reduction for the final pay period. But if they do, if the lower pay rate is provided for in the wage agreement that is signed by the employee, then it's enforceable because the employee has already agreed in advance that that's what the pay rate will be if they don't do things right. So be really careful about that. Also, don't base the pay rate reduction on something that the employee cannot control. So you don't want to penalize them just for being alive. You want to penalize them for doing something that they really shouldn't have done. And you can cover that in the wage agreement if you're cautious about it. As far as wage deductions, remember they should always be authorized by the employee in writing. We recommend the separate standalone written wage deduction authorization agreement like is in the book. Don't just provide for it in a policy. That's unenforceable unless it's separately signed or if it's referred to on the acknowledgement of receipt page signed by the employee and for the handbook, and it refers to that policy. That's real cumbersome. Just do the smart thing and have it in a separate standalone wage deduction authorization agreement. Fringe benefits promised in a written policy or other form of agreement. Remember, those are enforceable under the Texas Payday Law. You want to be really careful and make sure that you promise no more than the company is ready and willing to deliver. Time off requests in policy. It's always good to provide a formal procedure for requesting time off. Remember, a company is not under any obligation to grant time off. Under Texas and federal law, you can legally work an adult unlimited hours each day, 7 days a week, 52 weeks a year, 365 days year round, with no time off for holidays or nighttime or weekends. The only limitations are industrial realities, common sense, and your desire to not have to replace people who burn out too easily. So you want to be real careful, of course. Most companies have sensible, workable work schedules, but the bottom line is that you don't have to grant time off just because an employee asks for it. So establish a procedure for requesting time off. Best way to do it, have employees submit a written request for approval of time off, and then grant or deny that request in writing. So that way everybody has the request and the reaction documented. So if somebody asks for time off and it's not convenient for the company, you can ask them to designate some other kind of time off. Policies governing off-duty conduct. Hey, that's my personal business. Don't I have the right to do that? Well, no, you don't, if it hurts the company or a coworker or the public at large. So that's where private business becomes company business. If what an employee does on their own, on their time off, impinges upon the workplace, such as violating the rights of other people. One of the good examples of that is sexual harassment. I mean, the law case books are full of cases of sexual harassment claims and lawsuits based on conduct that happened off duty. It was like at a company party, or somebody goes over to somebody else's house and, a coworker does something inappropriate to another. That's totally actionable under a policy because, it involves a workplace relationship. It involves relations between coworkers. And if something damaging happens, that becomes company business. So provide for that definitely in the company policy. Under current Texas law, the sexual harassment reports have to be immediately dealt with. So that takes top priority. And there's even individual personal liability of anybody who is in a position of management or to do something about it. So you want to be really, really careful on that. Workplace violence. The only type of workplace that absolutely has to have a workplace violence policy is a healthcare related facility, but it's recommended for any company. And really, this is one of those where zero tolerance comes in. There's no acceptable situation where coworkers should be hitting each other or calling each other terrible names or applying slurs to each other to where violence could result from that. So workplace conduct policies like that are always permissible and always a good idea. And let employees know what is expected and what will not be tolerated and what will happen in the event of a violation. Drug and alcohol testing, you want to provide, if your company does drug and alcohol testing, just remember, Texas law allows just about any kind of test at any time. But real important to cover in the policy, what will be considered a violation that will lead to a test? What employees are covered by the policy? How will the testing occur? What disciplinary measures might result from a positive result in a drug test? Does the company allow rehabilitation in lieu of discharge? If y'all provide for post-accident drug or alcohol testing, make sure that you also test anybody who may have caused a workplace accident or injury. If they caused an unsafe condition and that led to an injury of another person, then arguably, the one who caused the injury should definitely be subject to a test because they might have been intoxicated when they created the dangerous condition. The National Labor Relations Board has come out with, some pretty strict standards on company policies. And basically, they consider a policy problematic under the National Labor Relations Act if it, foreseeably has a chilling effect on somebody exercising their right to talk with other employees about their pay and benefits and working conditions. And, the test is if an employee who is economically dependent on the job, would they feel constrained by the policy? then it's probably a problem. So the only defense of that would be to show that it's for a legitimate purpose and a legitimate business purpose, and that a narrower policy would not achieve the purpose. So just be careful about that. Here's some examples of what the National Labor Relations Board has found to be a problem in the past, like Home Depot. They had a policy against no Black Lives Matter insignia on work aprons. The problem there was other types of personal insignia and organizations were allowed on aprons. So it was discriminatory to prohibit BLM insignia. No union insignia, same basic problem there. And also it had a chilling effect on National Labor Relations Act rights. They had another problem with a policy prohibiting covert recording of talks with managers. That's because the NLRB takes the position that employees have the right to obtain evidence of violations of the National Labor Relations Act so they can record supervisors. Now, keep in mind, Texas is a one-party notice state anyway, so your employees, aren't violating any law if they record you while you're talking with them. So just keep that in mind. That's a good general guide. Just be careful what you say and how you say it. Workplace privacy policies. A good starting point is that all employee information is private and confidential and will not be released. But there might be a legal reason to release it or a legitimate job-related reason. If so, go ahead and release it. But just be careful and make sure that all information requests go through a central person or office. Personnel files, common question, do we have to give copies of personnel files to employees? No, you don't. Under Texas or federal law, the only exception is an OSHA injury or accident report about an individual person's injury or accident. So that's the only exception. All other company documents are company property and they don't have to be released to employees. And one of the things we recommend is keep separate files for separate purposes. Release personnel file information to prospective new employers like job reference calls only if you have written authorization. That's not a legal requirement. It's just a good piece of practical advice. It's a best practice. It's recommended by attorneys. The reason being that if you have written authorization from a former employee to release personnel file information to a new employer, then that makes it much less likely that that ex-employee would be able to find legal representation if they later decided they wanted to sue you. Regarding searches, a company basically has the right to search any part of its workplace, any area of its physical facilities, and they also have the right to require people who come in and out of business property to submit to searches. The problem comes about when you don't let employees know that that is a requirement. So what do? Basically, you adopt a search policy that lets all employees know that they don't have an expectation of privacy in any area of the company. And even if it's their work desk or work locker, the company can search that at any time. And if they come onto the premises, like with a backpack or a purse or an attaché case, they may be under a requirement, if you say they are, to open that container up and show you the contents. If that's in the policy, that is enforceable, and you can make that a condition of continued employment. So now, Katie, I noticed that we're getting close to the indicated end of the session, and I want to respect everybody's time. So if you want me to, I can close it here and just invite questions later.
Yeah, that would be great. We actually have 3 questions that we received. So if we can, I kind of put there in the chat, if they want to just hang tight, if they have the time to stay on, we can go through those real quick.
Well, very good. Yes. Well, we can do that right now if you wish. And everybody on the line, I'd just like to say that I've got a few more slides that I did not have time to get to, my fault, because I just say too much. But I would recommend that you would go through those slides and let me know if you have any questions. Okay, so Katie, what questions
Perfect.
did we get in the chat?
So we have one from Jose, and this is sorry, this is about prep time. So he says they ask teachers to teach it's a music school. They ask teachers to teach private music lessons. Some just show up and teach, others take the time to prep on their own. We don't have a policy on prep time. We just ask them to teach at a particular time. What should we do about that?
Oh, that's a really great question. And it brings up the possibility of a complete exemption from, overtime pay and any kind of pay requirements for teachers. Because if a teacher meets the Department of Labor definition of teacher in the regulation, and I believe that is in regulation 541.303 in their wage and hour regulations. It's linked in the book. So take a look at the link to that regulation for teachers in the book. But anyway, teachers are exempt from the salary or fee requirement for the overtime exemption. They're regarded as overtime exempt employees, and they don't have to be paid on any kind of basis. No minimum wage, no overtime pay, no salary. They can be paid whatever the pay agreement says. So if they meet the definition of teacher, then it doesn't matter that they have prep time before or after. It doesn't matter from a pay standpoint, because it's legal to just pay them the agreed upon compensation, whatever it is, for all of the time they spend, regardless of how much time it is. The only thing to keep in mind is that you want to make sure that teachers, because good teachers are hard to find, that they feel like they're being fairly compensated and that it's worthwhile to stay with that company. So you want to make sure that they are treated fairly on compensation and that they are adequately compensated.
Okay, we have another question from Lee. How do we designate white collar employees? I see the examples, but how do we define that for our particular business?
It depends upon the business. So basically, in most companies, the top executive staff, the people with hiring and firing authority, and they supervise 2 or more full-time employees in such jobs, those people are going to be executive exempt. Administrative exempt employees are the back office staff, the ones who are responsible for managing aspects of the business or departments or divisions of the business. That would be anybody at the vice president or chief financial officer level, anybody in charge of a department like payroll director or HR director, head buyer, head dispatcher, department manager, general manager. All of those people are back office staff, and they are administrative exempt employees. Professional exempt employees are people who have at least a 4-year college degree and usually a state license or certification in order to do their jobs. And those are the so-called learned professionals like doctors, lawyers, teachers, engineers, architects, scientists of various kinds, pharmacists, veterinarians, registered nurses, physicians assistants, and people like them.
Okay, great. We have another question from Jose, and this is on the non-compete agreements. For music schools, there is a valid concern about teachers taking students away from school to start teaching them independently. That's why we have a non-compete agreement. Is there a better solution that will protect a school against this threat?
I would say that under current conditions, until we hear more from the appeals court, if the Federal Trade Commission appeals that Texas court ruling invalidating their FTC, their non-competition agreement ban, it would be a good way to handle that. Another way to handle it would be in terms of, if there is some kind of a bonus payable after somebody leaves employment, that bonus could be denied to anybody who takes one of the students in violation of a non-solicitation agreement. But a non-solicitation agreement would be a good way to handle it because technically it's not the same as a non-competition agreement, and it's subject to less, regulatory oversight. It's easier to draft, it's easier to enforce, but it should be done with legal counsel.
Okay, and those were all the questions that we have. I know that I was looking through the slide deck, and I know that there's still a lot more information that we weren't able to get to. So I'll get with you on, after this, Mr. Simmons, and hopefully we can do maybe a follow-up to this. And we also had, some really great questions here. So I do want to remind everybody who's still on the call, you guys will receive a recording of this. So be looking out for that in the next probably day or two before the week is over. If you have any other questions for Mr. Simmons, please, if you weren't able to get his contact information at the beginning of the presentation, you can reach out to us and we will absolutely get that to you. We want to make sure that we get all of your questions answered. So I think that's all we have. Anything else, Mr. Simmons? I think that's it.
No, just please share my contact information and
Absolutely.
let the attendees know that they should not be shy and contact me if they have any questions. I'll be glad to address them.
Perfect. Thank you so much for doing this for us. We really, really appreciate that. And thank all of you for logging on today. Sorry, my dog's barking in the background. And hopefully we can do some sort of follow-up. So everybody be looking out for that. Thank you all. And I hope you all have a great rest of the day and a great rest of the week. Bye-bye.
Thank you. Bye-bye.